There is a mechanism called the Judgment Fund. It appears in no law you've read, and it has existed since 1956, drawing directly from the United States Treasury with no dollar limit Congress ever has to approve again. It lives inside a single sentence of federal code, Title 31, Section 1304. No one voted on a number because there is no number to vote on. By the time this sentence ends, it has already paid something out. And by the end of this video, you'll understand why nobody can stop it. Here's what it literally is. Most federal agencies operate on a budget. Congress sets a ceiling every year, and if an agency spends past it, that's a crime, a violation of the Anti-Deficiency Act. But the Judgment Fund doesn't work that way. It's what's called a permanent, indefinite appropriation. That means Congress pre-approved it once, decades ago, and never has to approve it again. When the federal government loses a lawsuit or settles one, the money doesn't come from the Justice Department's budget. It comes from this fund. Automatically. No hearing, no vote, no ceiling. It came from a narrow fix. In 1956, Congress was tired of passing individual bills every time a court ordered the government to pay a claim, tort settlements, contract disputes, small change by federal standards. So lawmakers created a standing account to handle it quietly, administratively, without clogging the legislative calendar. That was the entire justification, a bookkeeping convenience. Nobody in that room imagined what it would become. Over the following decades, through recodification and agency interpretation, not new votes, just paperwork, its scope quietly widened. Civil rights violations, discrimination claims, constitutional torts, settlements running into the billions. Each expansion happened through regulation and Treasury guidance, never through a bill with your representative's name attached to it. The fund grew the way water finds cracks, not through force, through absence of a wall. Here's the part that changes who's actually accountable. The Bureau of the Fiscal Service processes the payments. The Justice Department negotiates the settlements, but neither of them is the agency whose conduct caused the harm. When the FBI or ICE or the Bureau of Prisons does something that costs the government millions in damages, that money doesn't come out of the FBI's budget or ICE's budget or the Bureau of Prisons' budget. It comes from this fund instead, which means the people who caused the expense never feel the expense. Remember, no one voted on this arrangement. It was never debated as policy. It was filed as accounting. Now consider what that actually does to an ordinary person. Say a federal agent conducts an unlawful raid, or a prison guard's negligence gets someone killed in custody, or an agency retaliates against a whistleblower and loses in court. The victim gets paid, often years later, often a fraction of what a jury awarded. But here's the mechanism nobody explains. Because the payout comes from the Judgment Fund and not the offending agency's own account, that agency's budget request next year is untouched. No line item shrinks. No supervisor has to justify anything to an appropriations subcommittee. The fund pays out more than $4 billion most years, spread across thousands of individual settlements, and there is no simple public ledger connecting a specific payment to a specific agency's specific failure. The paper trail exists, technically. Finding it requires FOIA requests, GAO reports, and patience most citizens don't have. The cost of misconduct is real. It is simply invisible to the institution that caused it, which means the institution has no financial reason to stop. And here's the part that should actually worry you: none of this is a loophole. It's completely legal. Every element was authorized by Congress decades ago in good faith to solve a paperwork problem. Repealing it now would mean unwinding the entire mechanism by which the federal government pays anyone it has wronged, which would mean either an Anti-Deficiency Act violation every time a court rules against Washington, or a return to Congress voting on every individual claim, which is precisely the gridlock this fund was built to escape. The structural lock isn't malice. It's that undoing the convenience would break the government's ability to honor its own court losses at all. So it stays. Permanently, untouched by whoever holds power, because touching it would cost more than leaving it alone, which raises the real question. If a bookkeeping fix from 1956 can quietly absorb the financial consequences of federal misconduct, insulating every agency from the price of its own failures, then budget ceilings themselves may be far softer than they look. The number Congress argues over publicly might not be the number that actually governs. Somewhere beneath every agency's official budget, there could be another account, permanent, indefinite, already appropriated, quietly paying for what the public budget was never designed to cover. And no one has ever had to explain how many of those accounts exist.